Well, good evening, everyone, and welcome to another edition of WGL Live. Tonight's edition is called Oregon's Last Stand. So this is for all my good friends just down the freeway from us down there in the great state of Oregon. I have with me Tony Aiello Jr. Tony, welcome.
Good evening, William. Thanks for having me.
Hey, thanks, brother, for being here. Listen, before we get too deep into it, you got any shout outs? Any people who might be watching you want to say hi to? I always let the guests do that.
Hi, Mom. I'm just kidding. Hi, honey. My wife's watching right now in the living room.
All right, all the way over in the living room.
Yeah.
Hey, listen, thanks for coming on and doing this, and I'll give everyone the background of why how I reached out to Tony is so I covered ballot measure 114 when it was kicking around as a ballot measure and passed narrowly, and then looked at some of the challenges, including the challenge that happened out there in federal court, and I think Judge Ermagert got her hands on that one. Okay, was following the case out of Harney County. And all the victories we had there, and so I'm interested in this case. And some people in Oregon had kind of tipped me off. So I'm sitting there, and now Tony's been doing this for 5 years. I've been doing this for 30 plus years. So when I'm sitting there watching, like, okay, let's see what this guy's got. Let's see what he's got going on here. And what I saw, number one, was an attorney that was very passionate about the subject matter, what I appreciate. But what I really appreciated, and I said, I've got to get this guy on, is, dude, you did your homework. You really, really did your homework. I mean, you got some tough questions thrown at you. You obviously have prepared. So I want to start by just congratulating you because, like, sometimes we can't win the results because of the politics involved in this. But were you the better of the two advocates in the courtroom that day? I believe you were. So congratulations.
Well, thank you very much for that. Yeah, this has been 3 years. Next Saturday, I've been living and breathing this case law, the ballot measure. So I'm glad the 3 years paid off.
Well, this is a rare birth to grave case because I understand you took this. You're the guy who tried this case in Harney County.
I'm the one who did the temporary restraining order in Harney County. So all the way from TRO, preliminary injunction. We had 3 hearings on that, 2 trips to the Supreme Court on mandamus, and then trial, Court of Appeals, Supreme Court.
And you did it all.
I did it all with help in my office.
Birth to grave.
Yeah,
birth to grave. Now, listen, I will tell you that as a criminal defense attorney, I would always punt my appeals over to somebody else. So I didn't get to do a lot of birth to grave stuff, and I let somebody else make bad case law, not me. Listen, this has been it's been a labor of love, but it has not been a profitable labor for you or your law firm. And this is typically what happens when we get involved in really big Second Amendment litigation. It's not about making money. It's about the cause. You have a link down there because I know there's a lot of people that have been chipping in on that. Why don't you tell us a little bit on the link so that if anyone who's watching live or on replay wants to show you guys some love, how can they do that?
Yeah, absolutely. So we have a Give, Send, Go link. We launched that after trial. After trial, we lost our funding. So all the work post-trial has been essentially just winging a prayer.
Out of pocket is what it's been.
Yes. And I told my boss, I said, I think we can fundraise this thing. I think people care enough. And so far it's worked. We're about 30,000 in the hole right now as we sit here today. But so for everybody who's watching, my boss pays me, I bill hours, and those hours make the firm money. So when I bill hours, but we don't get money, boss doesn't have to pay me, but he is. And thank you. And please don't stop.
Right. Boss, take good care of Tony. He did a nice job for you.
Yep. So if you can chip in, we did right after the Court of Appeals. We really ramped it up, and that's when the fundraising really started coming in.
Good.
And I told everybody, let's call it the 2025 challenge. Chip in $20 or more and share by direct message with 25 people you think that would jump in, and that got us quite a ways.
Great. That's great advice. So like I said, folks, down in the description box is the link. Show some love, especially you guys in Oregon, man. These guys have been just absolutely battling like holy hell. So get some skin in the game here. Help these people out. All right. Now, we're going to talk about the case tonight of Arnold v. Kotek, which was just argued in front of the Oregon State Supreme Court last week, right? Or was it a little more than a week ago now?
Yeah, 2 weeks to the day.
Okay. Now, I had been following this case, and the one thing that I did not have a high level of understanding about until I sat down and read your briefs, okay? And I think a lot of other people were asking this, and some people in Oregon may be asking this question as well. This is not a Second Amendment challenge to ballot measure 114. This is a challenge that is brought exclusively under Article 1, Section 27 of the Oregon State Constitution, correct?
Correct.
Okay, now, as we're an educational channel, let's just remind everyone that the people shall have the right to bear arms for defense of themselves and the state, but the military shall be kept in strict subordination to the civil power. Here's my big question, and this is a great place for us to start with the educational component of what we're talking about here. What was the strategy of going exclusively under state constitutional grounds?
Yeah, so Oregon Article 1, Section 8, that's our free speech provision. The Oregon Supreme Court's interpreted it to actually be stronger than the First Amendment. And so our theory was kind of twofold. Number one is I read that language and there's no kind of this antiquated language about militias. We're rednecks out here in Oregon, not in the Portland metro, but you know, they our pioneering ancestors really stated it more plainly than the
well, and you bring up a good point, because when you look at the historical formation of Oregon, there was that Wild West pioneer spirit to it.
Yep. And then also, I think it's important for us to not neglect our state. You know, a right that you don't use, you lose. And so we have this right. The case law was really old. All of the stuff about bans was really good for us, and we said, let's try it.
Okay. So when we decided to call this thing Oregon's Last Stand, as it relates to Arnold v. Kotek, this is the last stand for this case. This case has nowhere to go once the Supreme Court issues its ruling.
And then also there was a federal case that existed already, so we knew that was being handled.
Yeah, I want everyone in Oregon to know it doesn't mean that this is the only challenge going on. Mm-hmm. There was one that actually, I think, unfortunately ended up in Portland, right?
Yep.
Yeah, and I don't remember the name. Was that Oregon Firearms Federation v. Kotek?
Yes, there's 5 different cases that all got consolidated. I know Off is one of the plaintiffs. Yeah. I believe there's a sheriff who's a plaintiff as well.
Oh, kudos to that sheriff.
Yes.
Now, listen, I watched the oral arguments a couple times. I read your brief. I read Oregon's brief. Really well drafted brief too. And this is kind of what I've learned, and it really came out in the oral arguments, is that this is a massive versus. And what I mean is it's a competition between 2 well-established legal theories in the state of Oregon. The first one, and I want you to explain, and I think this is one of the big reasons that you guys decided to do this under state constitutional grounds, is that historically speaking, the types of limitations that could actually be imposed by the legislature in Oregon was incredibly limited. Why don't you tell the viewer about that? This is a really important component of your argument.
Yeah, so kind of the threshold question is this restriction even constitutional? And what the court said in State versus Kessler, this is a 1980 case, is let's look back at history and see what from England through the Second Amendment, as far as it applied pre-statehood, and then the Indiana Constitution and other constitutions that we borrowed from. Let's see what they the constitutional restrictions they allowed. And broadly, the court said that it was restrictions on certain manners of use and manners of possession of arms, and then certain dangerous persons, namely felons. And so those are if the state can't point to a law in history that supports their argument, it's unconstitutional.
So just again, so that the viewer understands, according to your historical analysis of case law as it relates to the Oregon State Constitution, there was only very limited restrictions, which was manner of use, manner of possession, and then a barring of certain dangerous individuals. Is that right?
Yes. Yeah.
Okay. But there's this other, here's the great competitor to it. There's this other rule of law, one that the state of Oregon was pounding away like a drum, which is the legislature's authority to enact reasonable regulations so long as it does not unduly frustrate armed self-defense. Is that really the rule of law in Oregon?
Well, if it is, then anybody can call anything reasonable, and that's it. No,
that is it, isn't it? Right.
Yeah, that quote comes after 3 pages of going over the history in a case called State v. Christian that was in 2013.
Let me play something for you here.
Yeah.
Let me play something.
A test that looks like this court adopted in Christian said, we've consistently acknowledged the legislature's authority to enact reasonable regulations. You take issue with the reasonable analysis.
Yes, Your Honor. So no case before Christian used the word reasonable.
Okay, so do we have to overrule Christian in order to adopt your view?
No, Christian, so the quote of the word reasonable comes after, if I remember right, a 3-page explanation of the manner of use, manner of possession, which comes from Kessler, Blocker, and Delgado, and the certain dangerous persons, namely felons, that comes from State v. Hirsch-Fremd. It summarizes those. At the end of it, it says, we have consistently acknowledged that the state may enact reasonable regulations. It's summarizing it.
So that's when that was early on in the argument. And I was like, that's when I was like, okay, this dude did his homework.
Yep, so that's what he said is true. And really, reasonable. Those are the ones that have been recognized as reasonable. So it
manner of use, manner of possession, and restricting certain dangerous people.
Yep.
Okay. Now, let me ask you. You got pushed back. I think there was another judge that pushed back on you a little bit on this. Well, let me play this.
So, counsel, the Court of Appeals opinion concluded that this is a manner of use regulation. They basically reasoned that the law doesn't prohibit any particular firearm. It just prohibits the use of the weapon in a way that would enable firing more than 10 shots without reloading. Why was the Court of Appeals wrong to see this as a manner of use regulation?
What's the answer?
The dictionary definition of manner is a mode or procedure, way of acting. And that's quoted in the brief. And so it's how you use something. It's not whether or not you can have it in the first place. So
you made another argument also, like, what's the inverse of that?
Yeah.
Remember that?
Yep.
Tell us about that. It was a good argument.
Yeah. So if you ban magazines, if you ban conduct, carrying a magazine that can hold more than 10 rounds, then you're not really banning the conduct, you're banning the arm.
The arm.
Yeah. And I think that was to a question about safeties. They said, can we require you to have a safety?
Okay, this is a great segue, because guess what the next video clip is I'm going to play. But that was, and when you're doing these arguments, and we'll see some other arguments where they start getting into the whole, they're trying to tease you about machine guns and all this other completely irrelevant crap. The question on safeties, I thought, it was a fair question. And let's play that, because I want to see, because this again begins to illustrate some of the pushback you were getting and some of the minefield that you have to navigate, because the lower court had said that this was a manner of use restriction, right?
Yeah, not really, kind of.
Not really, yeah. Well, what I gathered from the argument is the court hadn't really clearly articulated a lot of things, like, is this even a protected arm? All right, let's just check this out.
Isn't the presence of a safety mechanism part of regulating the manner of possessing an arm? You can possess it as long as it has this particular feature.
Well, that would be banning. So look at the inverse of it. it would be prohibiting the arms that do not contain that. That's quite different from the manner of use, manner of possession cases that this court's
But isn't any
considered.
regulation of manner of possession also a ban on whatever violates the regulation?
But it's not on the arm, it's on the conduct. So one can carry a firearm, open carry, or concealed. So a ban on concealed carry would be a ban on a distinct manner of possessing it. It's not on the arm itself.
All right, Tony, just so the viewer understands, there really are two distinct issues inside of what we're challenging here on ballot measure 114. There is the magazine ban, and that's the one that seems to get a lot of attention. But let us also remember that there is this permit to purchase, permission slip, hall pass, whatever you want to call it, right? And it seemed to me as though some justices were more caught up on one issue than the other, and vice versa. What was your impression, since you were obviously in the courtroom?
Yeah, so Justice James was definitely interested in the permit. That was his main concern. Chief Justice Flynn asked me a couple questions about it, but Justice James really did not like the permit. It seemed.
Yeah. Well, I noticed that one of the things they talked about, Justice Flynn was talking about the objective conditions, similar to when before we went live, you and I were geeking out a little bit about Bruin footnote 9 and the objective conditions, which, by the way, on a side note, deals with carry restrictions, not possession. See that as okay. But then there could be this potential subjective criteria, which is a big, huge no-no. Why don't you tell the listener about what Flynn brought up and where you, as petitioners, coming down on that whole dilemma with the permit to purchase?
Yeah, so the state's arguing that you have to go through a mental health evaluation by somebody within the sheriff or police chief's office, and that requirement is objective. And whether or not somebody presents a likelihood of having a mental illness, to me, is an extremely subjective.
But is it all medical diagnoses at some point, some level of subjectivity to it? I mean, I get there's those instances like, oh, he thinks he broke his arm. We do an X-ray, the arm's in complete. Okay, objectively, the arm's not broken, right? But when we're talking about mental health issues in particular, isn't everything always going to have some level of subjectivity to it?
Certainly, and you can also have different degrees of it. So,
right.
Do you
like
have
we
to
got blood tests for these things? Like you draw blood and like, aha, clinical depression,
Yes. Yeah. Do you have to take depression medication or anxiety medication? Is that mental illness sufficient to remove your right to bear arms? Or are you, a paranoid schizophrenic who doesn't know what day it is? There's
right, or hears voices all the time. Right.
Yeah.
Well, but then again, under the historical analysis that you've been arguing, that would go down to certain dangerous persons. And does that individual lie within that certain type of historically accepted dangerous persons, right?
Right. And really, the case law on that is less definitive. So Hirschfriend says it's got to be someone guilty of serious criminal conduct that causes the legislature to believe that they would be a danger to themselves or others. There's also mental health illness, but all of those dealt with judicial determinations that someone's incompetent. So it's not a perspective denial of rights like this is. It's a post you've done something wrong.
Post adjudication.
Yes.
Post adjudication, where theoretically all sides have been heard and everyone's got due process, and then the court has theoretically used objective criteria and weighing their decision as to whether or not the person's incompetent, things like that. Here's another thing before we get to some of the other highlights from the argument. It appeared that the court, or some of the justices, had issues with the record. And what I say by that is had issues with the state kind of just saying, the record schmeckered. I want you to explain to the viewer the importance of the record and how this really can dictate how things can be appealed and what can be argued effectively on appeal.
Yeah, so fundamentally, the quintessential law school hypothetical question of fact is, was the light red or green? Those questions are decided based on credibility determinations and a whole host of things. And so on review at the Court of Appeals or Supreme Court level, what the court reviews for is any evidence on the record. So is there a single statement?
One iota.
Yeah. And then
scintilla.
Yes. And then for questions of law, those are reviewed de novo. There's no assumption that the person who heard the testimony heard it correctly.
Right.
And here, we had a great trial court judge. We had a 6-day trial. And as soon as we're done with the 6-day trial, here comes the state saying, well, none of that matters, Judge.
Right.
So hard to get in their evidence. And so that was really strange to me. I did not really see that coming. Well,
it's quite an exercise of futility to go through a 6-day trial for something that apparently didn't matter.
Yes, and we actually had arguments about that internally about, well, do we do like a lot of Second Amendment cases and go on motion for summary judgment? And I said, there's no way we can get past the public safety issue and the historical is this an arm issue without a trial. And so we opted not to spend the money to go the motion for summary judgment route. And if they didn't think facts mattered, they should have gone the summary judgment route, and we could have done that.
Right. Okay. All right. Well, all right. So now we've gotten through parts of your argument. Now we're going to get to the state of Oregon's argument. And you and I have made a gentleman's agreement, and I think this is the right gentleman's agreement, that any comments we're going to make has nothing to do with counsel record for the state of Oregon. Because candidly, anyone else who would have been in his shoes would have had to make the same kind of half-baked arguments. Okay, so
it's all about the argument, not the person.
It's about the substance of the argument and not the individual who's delivering it. Okay. Here's the big thing. There were a couple justices that were caught up on the fact that the lower court had found, allegedly, that these were protected arms. The magazines were protected arms. And yet, even finding that they were protected arms, under that test that we previously talked about, this one right here, the authority to act reasonable regulations, that they could still ban them whatsoever. And then they kind of, the state attorney didn't get too far out of the starting gates before he got hit with it.
Right. That's the legal principle, and that's sort of the legal framework.
But was the Court of Appeals decision in this case the first time that a court has held that something is a protected arm and still the legislature may completely prohibit its possession because it's a reasonable regulation? Has that ever happened before?
Not to my knowledge, and I don't think it actually happened here, Your Honor. I mean, so the court assumed it was protected without actually deciding the question, and then it just proceeded to say, well, even if it were, so there's, in the text of the opinion, and there's also a footnote that reiterates that we're not addressing this question.
Okay, but it's the same idea, right? It stands for the idea that the legislature's authority to reasonably regulate arms would extend to the ability to completely prohibit the possession of an arm for even by a person who's not a felon.
Okay, now I'm going to assume that that has never happened before in Oregon jurisprudence. My question to you is the state attorney says, well, that didn't actually happen at the lower court. What really happened at the lower court?
Well, so I think he was referencing the Court of Appeals. But
yes. When I say lower court, the court below you. Yes.
So the Court of Appeals said, Judge Mooney actually had a quote in oral argument where she said, yeah, but we've had, and she did like this. She said, we've had guns that could shoot multiple bullets for a long time, so I don't understand what your argument is. So the Court of Appeals said that magazines are part of a protected arm. Firearms, it's inappropriate to parcel out a firearm from its components. And that because the Colt revolver was extremely common in the West, especially in 1859, it shot between 4 and 8 rounds on average revolvers at the time. The jump to 11 is not a huge jump. It's protected arm. But they didn't delve into the record. They just said, yeah, it's an arm. So they didn't adhere to that distinction I was talking about between questions of fact and questions of law, where they should have said, well, here are the arms that existed. Those had.
But the factual finding of the trial court, which was left undisturbed by the Court of Appeals, was that these constituted arms, protected arms.
Exactly.
And if it's a protected arm, then there is no restriction that would be reasonable as it relates to that protected arm, right?
Yep. At the risk of having video me say it better, State versus Delgado says this the Constitution does not allow. That's the final paragraph.
I like that. Well, you mentioned there was some other pushback about this. Here's the pushback I think you were
So,
talking
counsel, the Court of Appeals first question of whether it's a protected arm at all.
And I'm curious about that because the state has done that in its argument now, going directly to the standard. So I'm curious, is the state suggesting that we also assume for purposes of our review of this case that this is a protected arm? The state does not appear to be conceding that it is, but where is the state on that?
It's up to this court's discretion whether you want to address one or both questions. I think either avenue affirms the facial constitutionality of the large capacity magazine restrictions.
How can a finding that it is a protected arm, either or, as counsel put it, again, not ripping on counsel, I'm ripping on the argument.
Yep.
How, if it's a protected arm, can it be constitutional? I'm still struggling with trying to get my head around that concept.
Yeah, I can't find case law. Case law does not exist. At this point, I know all the case law. Case law does not exist that says you can do that.
I bet you do.
The other big issue kind of behind the scenes for folks that didn't read the brief start to finish is what they did was really shady. We petitioned for review. And what you're supposed to do is if the winning side still has an issue with the Court of Appeals, even though they won, they can do what's called a contingent request for review. So they say, you shouldn't review this because we won, but if you do, we want this question asked.
Kind of a cross appeal on a specific issue. They
didn't do that. So then I file my opening brief, and I'm just focused on the part assuming it's a protected arm, that part of the test.
Yeah.
They file their response brief, and they say, well, we're also appealing this factual finding.
But procedurally, they'd waived it at that point, hadn't they?
Exactly. So I believe it's Oregon Rule of Appellate Procedure 9.22 says it's up to the Supreme Court whether they want to hear it.
Whether they want to actually have this rule be a rule or just advisory in nature.
But the case law is way on our side. They say if you have an issue with the Court of Appeals, you should have raised it before. So typically they don't. I think that portion of the rule is meant to do things like address attorneys' fees and kind of these non-merits questions or an evidentiary ruling that they want to opine on because we're there and the case presents it. But it's not for the fundamental question, does the Constitution apply here?
Did the Court of Appeals actually author in their opinion that it doesn't really matter whether this is a protected arm or not, or was counsel for the state overgeneralizing?
Overgeneralizing a little bit. They said that we assume it's a protected arm. We're not going to parcel out and
well, then the question from the bench was a real fair one, because if they assume it's a protected arm and yet they still allow the ban anyways, that would be the first time in the history of the state of Oregon that a protected arm was allowed to be. It sounds like a pretty fair question now.
Exactly. It was a very fair question, and I really appreciated Justice DeHoog jumping in there, because they do present in their brief two questions. Does the Constitution even apply? And if so, it's still reasonable. So that was the way they phrased the argument for the court.
Has the state of Oregon ever articulated where the lower threshold is where they think they can't ban anymore? Is it 5 rounds? Is it 7 rounds? Have they ever done that?
No. Well, kind of, a little bit.
Well, here's why I ask. Are you familiar with the magic bullet theory?
Is that the Barney Fife rule?
No, but I know that. I know that.
Okay.
No, the magic bullet theory. Actually, there's a brief writer, one of the guys that does all the appeals for National Association for Gun Rights, a guy named Barry Arrington. dynamite lawyer, dynamite brief writer, writes kind of these sarcastic, humorous briefs. So I always really enjoy them. But he talks about this magic bullet theory, where presumably in states, the Constitution protects magazines that hold up to 10 rounds. But suddenly, when you add that 11th round to it, this magic bullet transforms it into something which is no longer constitutionally protected. And I think one of the justices right here kind of tried to corner the state the same way.
Well, can I ask you about that? Because if I understand your brief, you acknowledge that weapons that range from 4 to 8 repeating shots were common for self-defense?
Yes, Your Honor.
And so your argument is premised on 11 being significantly different from 8?
Yes, and it's significantly different for two prime. Well, it's significantly different for the technological reasons why that was not commonly used for self-defense. They didn't really exist at the time, and it's also significant because of the public safety risks that are posed by magazines of larger than 10 rounds.
Okay, now again, with all due respect, I think you got caught a little off guard by that question, because you could see the wheels spinning, and he's just kind of spitting words out like, I got to get some thoughts together. I got to get my feet. Trust me, it's happened to me too. It's probably happened to you also, right? You get knocked off your feet by a question, you're like, all right, I got to stall out here for about 10 seconds and gather my thoughts pretty quick. But it is an interesting way of looking at it, because where does the limit lie then? Where does it lie? When the 10-round magazine in Oregon doesn't save lives, because no magazine ban ever has, no magazine ban ever will, does the legislature come back and say, well, shoot, man, we probably need to drop it down to 7 now?
Right. Yeah, exactly. There's no gun that our legislators here in Oregon, half of them roughly, don't want to ban. And they can pretend otherwise, but when they start talking about semi-automatics are not protected arms, they want to ban every gun.
But because that's how they work. Yeah. But he said something else that I don't know how many people caught this. He was talking about, again, trying to limit it to the right of self-defense, but then he also said, well, but you wouldn't get to use those because those didn't exist at the time. Is the state of Oregon suggesting that the only arms that can be used for self-defense are those that existed at the time that your state was formed? Because that's not a lot of people carrying those around anymore.
Yeah, they won't outright say it that boldly. What they say is, well, yeah, Delgado accounts for improvements in modern design and function, but really it should still do the same thing. And so that's where he was getting into how long it took to load a pepper box revolver. And it's okay, so firearms sucked back then. They did compared to now. But that's not how we interpret the Constitution.
But if this becomes the acceptable rule of law in Oregon, then they literally could turn around and ban just about everything, couldn't they?
Yeah, I don't think at that point it matters. If reasonable, and that's a point we make in our brief, is if their test is correct, then Kessler, Blocker, and Delgado, those are our big three Article 1, Section 27 cases. Those were all wrongly decided. Because
So the funny thing is that one of the very first questions asked out of the gate was, do we have to overrule Christian for you to win? When in fact, what you actually have to do is you have to overrule the entire body of case law for Oregon to win.
Exactly. Yeah. The Kessler, Blocker, Delgado are all three really, really clear cases. Christian's a little bit foggier. And so, not everything.
The one that has that summary in there, right? You got 3 pages and then the summary. And see, this is we deal with this crap all the time with Heller, because Heller said the Constitution protects those arms that are in common use for lawful purposes, such as self-defense. Now it's suddenly turned into it only protects arms for self-defense. No, it protects arms for all lawful purposes, just like this reasonable word. This is why I get so angry at like John Roberts that writes the Rahimi opinion and scatters all this sloppy language in there. It comes back and it haunts us.
Yeah, and it's hard for attorneys to argue around too, because yeah, they said it, and so sure you can cherry pick quotes, but let's read the opinion.
Well,
Opinions aren't
and
meant
kudos
be
to
read
you.
sentence by sentence, you know.
Let me play this clip for you here, and then I'm going to ask you.
Let's suppose that the drafters know that there are attempts to make these things. And so maybe we then can infer from the historical record that the drafters would have anticipated that with technological developments, these things might become prevalent and common within a few years. What's your best evidence and argument that with that understanding, the drafters wouldn't have wanted those developments to be available for self-defense purposes?
I point this court to Delgado and Kessler, but Delgado said this a little bit more explicitly, where the framers believe that their interpretation was that the framers were codifying a right to bear arms of what was commonly used for self-defense at the time of statehood.
All right. Is that yeah? See you shaking your head because you know
The quote's not in there.
no, it's not even in there.
No,
Okay.
nothing
This is the
like
Delgado
that.
case, right?
Yep.
All right. Now, if that quote's in there, tell me why then they couldn't just. You're entitled to like whatever revolvers were around and when you guys become a state? 1859, 1854? Yeah, 1859. So. Yeah, so any firearm that was in existence in 1859 is usable for self-defense. Anything that come out after that, not protected under the state constitution. Yeah. Is that what Oregon's suggesting here?
Oh, yes, that's what the state's arguing. And Delgado is actually so good. There's two footnotes that are really interesting if anybody wants to go read the case. One of them is the court notes that technology was proceeding apace. And they say this is the period of development of the Gatling gun, of all these big breech loading weapons, metallic cartridges. The drafters of Oregon's Constitution knew they were living through a renaissance. Even the state's expert conceded that they would have envisioned arms that could hold more than 10 rounds. And the other footnote, though, is really interesting. They say, we don't now comment on what tests should be applied to arms that could not have been foreseen. And as an example, they cite, I can't remember if it's pepper spray or stun guns, but they cite one of those and they say that's going to be an interesting discussion later. We'll have to have a discussion about whether that's an arm. But
well, but the thing is that
it never was adopted.
Well, if constitutional rights didn't grow with us as a society, then the First Amendment would only protect that which was written on hemp paper and would only protect the 9 all-Christian religions that were actually recognized at the time that we had the Constitution. And the Fourth Amendment the only type of search and seizures would be government agents just kicking your door in and rummaging through things because electronic surveillance didn't exist at that time. For you Eighth Amendment fans that aren't fans of cruel and unusual punishment, we've come up with all sorts of new ways to execute people since that time. Yes. And do we suggest for any 1 second that any of those constitutional rights don't still apply in some manner to those items?
No, right to bear arms is a second-class right that isn't afforded the same constitutional. That's their argument. That is the only thing that they can lean on, other than public safety and standing on the graves of children. That's their two arguments.
Well, and I did appreciate, again, we said we weren't going to be critical of counsel for Oregon. Here, I'm going to give him a compliment. He didn't do what I see a lot of advocates of civilian disarmament, which is they want to get up and they want to start talking about horror story after horror story after. They don't want to focus on the law. They don't want to focus on the Constitution. They just want to tell us gory story after gory story. He didn't do any of that. He engaged in I know they argued about how, this is necessary for public safety, but he didn't really, but he didn't go overboard with it. So let's give him credit for there. Okay.
Definitely.
Let's circle back to this permit to purchase, because when ballot measure 114 was kicking around, I was screaming bloody murder to Oregon that, hey, this is by far the most offensive thing, because again, we are taking a right and turning it into a privilege. Justice Flynn appeared to not be a fan of that. Let me play this clip for you first here, because I think he had a question about, is it possible that by engaging in one type of constitutional activity, you could actually be jeopardizing a different type of constitutionally protected activity?
Let's suppose that the drafters know that there are attempts.
I'm curious because threat of unlawful violence under our Article 1, Section 8 jurisprudence, under Robertson and Moyle, a mere threat of unlawful violence is protected speech, right? It need to get to an Article 1, Section 8 ability to sanction that, it needs to be a genuine threat of unlawful violence, and there has to be a presence of imminence and a reasonable likelihood to carry out, right?
Yeah.
So do I read this correctly that somebody can be deprived of an Article 1, Section 27 right based upon their exercise of an Article 1, Section 8 right?
No, because the law would have to be applied constitutionally.
All right. Now, you and I were actually talking about this before we went live. All right. So is Justice Flynn onto something? And number two, well, actually, let's do it this way. Explain to us the clause in the approval process that Justice Flynn had a concern about.
Yeah, so that's Justice James.
Pardon me, Justice James.
Justice Flynn's is the one
That's
in the
right.
center.
Chief
But
Justice. That's right.
yeah, Justice James was referencing essentially the mental health evaluation. So the sheriff can look beyond your criminal record and look at contacts that they've had with you in LEDS, the law enforcement data system. And so if there's been threats of violence or if there's been
Allegations.
allegations of domestic abuse, anything like that.
But
that
something that
can
didn't
result-
rise to the level of probable cause and end up in an arrest. They could be, and sometimes you're a criminal defense attorney, you've done this work, I've done it too. Sometimes those allegations are BS.
Sometimes they are.
Yeah.
Yes. And so that lends itself to a very subjective test. You know, you're going to get it applied differently in Harney County than you will Multnomah County. And so subjectivity doesn't work, especially when we're dealing with a constitutional right.
No. And the danger of subjectivity is it allows any politically motivated court on either side of the spectrum, just to be equal here, the opportunity to just put their thumb on the scale.
And law enforcement too, you know.
Oh, absolutely.
Just runs into this guy a lot. I could actually foresee it being worse in a small county where that's Crazy Greg. We don't like Crazy Greg.
Crazy Greg.
We're not gonna,
Yeah, Tony the
we don't
town
want to deal
drunk.
with them.
Right,
Yes.
Tony the town drunk, right? I mean, yeah. I mean, every town's got him. I got him. Okay, now I thought the highlight of this entire thing was Justice James, right? I want to make sure I get the justice right.
Yep.
Not that I think Justice James is watching, but if he is, hey, thanks for tuning in, Judge. But it was make sure I get the right one because I've screwed up a couple times and gotten the wrong clips.
I'm curious because threat of unlawful violence.
No, I screwed it up. I got to tell you, man, I am technically just being a total dumbass tonight. This is the correct clip.
Can I ask you another question? Is there any other example where a citizen of Oregon would need to take a class before they could exercise their constitutional right?
I don't know. And I don't know if I don't think of driving as a constitutional right. I assume it's not.
No.
I think the answer to that is no, but I hesitate to say that definitively.
So Article 1, Section 27 talks not only about the possession of arms, but as we've heard, it also talks about self-defense, right? I have always, I guess, guessed that self-defense as a concept, as a legal concept, is constitutionally protected by Article 1, Section 27. Like, the legislature couldn't eliminate the defense of self-defense that might pose constitutional problems. Could the legislature say you can't avail yourself of the defense of self-defense until you've first taken a class about self-defense? Until you've taken the class, you just have to stand there and take the beating.
Well, Tony, what's the answer to that question?
Of course, there's no other constitutional right that. I mean, I think there was better answers out there than driving. You know, we could look at FCC laws and broadcasting laws, things like that. But we had actually kind of cut that off in our brief and said those are at best analogous to public carry of firearms, because there's some public aspect to it. Sure, you might need a permit to have a parade. That's in public. It has nothing to do with the content of what you're doing. Right. This is more akin to needing a license to worship in your own home.
Right. Or until you take a class, you are not free from unreasonable government searches and seizures.
Yes.
Or until you get your permit, you're actually going to be forced to incriminate yourself. But once you got the permit, then you can go ahead and lawyer up.
Yeah. Now that we know you will exercise those rights responsibly.
Yeah, right. You demonstrated the exercise. Well, trust me, lawyering up is the yes. responsible exercise of that right. Yapping to the cops is not. So, okay. Now, I thought, and we're going to get to your one. I got one last clip to play, which is your rebuttal argument. I thought, and again, you're the guy in the courtroom, so you tell me. But I thought the state of Oregon's attorney got more pushback and harder questions from the bench than you did. What was your? I'm not saying they went light on you, but I think they went a little harder on him. But what do you say?
I would say that I felt a little bit teed up for my answers, but also I know I was well prepared for this.
You were.
So those might have seemed. If I was less prepared, they might have seemed like a gotcha. For example, the fully automatic, the question of how far does this right go? That might have been. I've been frankly thinking about the answer to that question for 17 years. So
well, and then you and I were talking, man. We're always replay a trial or an oral argument in our head, and we're always like, "Damn it, I should have," And I thought it was a totally unfair question. For those of you not aware, and this is something that it's not unique to what happened in Tony's case here. This is very unique when you talk about assault weapon bans. You listen to these arguments, they're always like, well, I suppose you're going to argue then that machine guns can be legal too. And they kind of tried to push you on that.
Yeah.
I thought you did a good job. You dug in on it.
Yeah, I mean, I think certainly fully automatic arms are arms and protected. Where it gets more difficult is things that aren't bearable arms. So that's where I said hand-carried personal defense weapons.
Yeah, tanks. Pretty hard to bear that.
Yeah, that's a tough one.
Yeah.
Nukes definitely not.
Yeah, F-15s. I mean, it'd be cool to have them, but let's face it, those are not bearable arms.
Correct, yeah.
Okay. Now, you want to know where I really thought you teed it up? I thought you started strong. It's always nice to start strong. It's always nice to end strong. This is your rebuttal. And I expected when this question came up, I expected Tony Aiello Jr. to give a much more technical answer. And I think, and you can correct me if I'm wrong after we're done playing the clip, I think you stepped back out of, I'm going to be technical lawyer guy, and I'm going to give you a very broad answer. And I love this, so I want to play this.
In your view, what are the underlying principles? What were the goals or objectives of the people who drafted Article 1, Section 27?
To allow people, and her friend delves into this as well, the ultimate goal of any right to bear arms is the ability to repel a tyrannical government. There's also state defense. There's also self-defense, defense of others, protection. Kessler goes into the exigencies of rural living, protecting your livestock and family from predators, be they wolves, bears, cougars, people. Those are all encompassed within the right to bear arms. And her friend specifically calls out the ability to repel foreign governments or to protect the citizens from a tyrannical government, which, going back to the text of Article 1, Section 27, is why state defense is very relevant.
I love it, man.
Yeah, that one was a little bit more off the cuff than I had anticipated it, and my answer changed in the moment.
Did it? It was one of those like, you know what? I'm not going to throw the out route. I'm going to go ahead and throw the bomb down the sideline here and just go for it.
Yeah. I mean, and it's in the case law, so they don't get to call me a nut. Their predecessors wrote it, and obviously, even their predecessors wrote it when you deal with the Second
Well,
Amendment.
Tony, and that's one of the things I thought you did is you continuously tied everything you said back to a case. And I know there was a limited number of cases under Oregon case law, but you knew them backwards and forwards, brother. You did a nice job.
Thank you. Yeah.
All right.
Yeah,
Now
tying
you
it
got
back
one
to
more.
case law is helpful because
All right.
now they don't have to worry about overturning old case law.
Well, guess what we get to do now, real quick? Oh, now I want you to know we're going to look into our crystal ball, but I'm not going to hold you accountable for all this. Okay. This is like, I don't know. But here's the thing. You got 7 justices there, right?
Yeah. 7.
Okay. We got Flynn, DeHoog, Garrett, Duncan, Bouchon. We had Tukey, who I think was sitting as pro tem for, is it Masai?
I think they say Mozzie.
Okay, Mozzie.
Yeah.
Okay, so pro tem Tukey and then Justice James. Okay? And we have 2 issues here. One is mag ban, and the other one is permit to purchase. Okay? So I'm gonna keep track here. And again, I'm not going to, if you turn out to be dead wrong, you probably would have been just as dead wrong as I would have been too. Yeah. So don't worry about that. Okay, let's start with the Chief Justice. On mag ban, thumbs up or thumbs down? What do you think she does with that?
I'm going to go thumbs, is thumbs up?
Thumbs up would mean she thinks it's good law.
Oh, no. Thumbs down.
So you think she's going to find the mag ban is unconstitutional?
I do.
Okay, what about the permit to purchase?
Thumbs down.
Okay. So that's 2 good votes out of the Chief Justice.
Yep.
All right. Justice DeHoog.
Justice DeHoog, I think the same. Thumbs down on both. He was quiet on the permits, but I've heard a little bit from some attorneys who were before him, before he was on the Supreme Court bench, and I think we've got him.
Okay. Justice Garrett.
I think Justice Garrett will go for the magazine ban and against the permit. I think he'll split.
So split vote there from him.
Yeah.
Justice Duncan.
Justice Duncan will go thumbs up on both, I think.
Okay. Justice Bouchon.
Thumbs up on both.
Okay. Oh boy, this is going to get close here, Tony. We'll go with the other justice before I get to the pro tem. Justice James.
I think Justice James will be thumbs down on both.
I think on the permit to purchase, that's absolutely guaranteed on that one. Okay, and then Justice Tukey, and was Judge Tukey a Court of Appeals judge that was just elevated for purpose of sitting pro tem on that?
Yes, and I've been in front of him more than anybody else. So
okay, so you got a good feel for this judge. What are you thinking?
Yeah. I think that he'll go against the permit for the magazine ban.
Okay.
He's a more difficult one to gauge, but I've read a couple of his opinions, and he's pretty mild. So. Okay,
so this is what you got, and again, I'm only going to write it on my notes. I will not publish it online. Of course, anyone can watch this.
Yep.
The magazine ban will be upheld by a vote of 4-3, and the permit to purchase ban will be struck down by a vote of 5-2.
And I think Justice Garrett on magazines and Judge Tukey are where I see some play on the magazine ban itself.
You realize if either one of them flips, you win on both. You win 4-3 on mags and 5-2 on permit to purchase. Oh my God. We will get you back on the channel then. We'll be throwing ticker tape parade.
Oh yeah.
You'll be coming down there. Where it's going to be drinks around Washington gun law that night, man. That would be awesome, brother.
Really, it depends on whether they decide to re-examine history for whether it's a protected arm. I don't think that the Court of Appeals opinion stands on magazines. The only way we lose on magazines is if they go back to the history and decide it's not a protected arm. Which
would technically have to overrule the trial court and the Court of Appeals, which just presumed it was a protected arm.
Yep. Yeah. So that would be that would be how it would happen, and I could see them not doing that as well.
Well, guess what, man? I had three pages of questions. I got through all of them. But before we let you go, I want you to put a plug in again for the Give, Send, Go account and how everyone out there in Oregon right now, we got almost 600 live right now with us. Thank you, everyone, for tuning in.
Yes.
And that is Tony Aiello Jr. He's the one fighting like holy hell for your constitutional rights down there in Oregon. So, Tony, once again, for those of you just joining us late, listen, I will tell you this. The way Second Amendment litigation works is you go out and you find a good client, and a good client just means they give you a good set of facts. It doesn't mean that they got deep pockets. They're not paying you for this crap, okay? You're doing this out of the principle. You're doing this because if people like Tony didn't do it, all of our constitutional rights would be taken. And you see this in First Amendment cases, whether it's freedom of speech, freedom of religion, all sorts of things. This is one of those many things. So I'm asking, especially for you down there in Oregon, man, get some skin in the game. These people have been battling like crazy on behalf of your constitutional rights. Help them out. Tony, how can they do that?
Yeah, so Give, Send, Go, the link's down below. You can also contact our office by phone or send a check to our address. Ultimately, if you want to stay up to date on Oregon specific issues, we've got Senate Bill 243 going off. Right now, we've got a lot of open questions. I
probably got an assault weapon ban coming in once you guys get back into session. So
yeah, they tried to do some nutty stuff. So the link,
I want to warm up your petition on that one right now,
yeah.
dude.
I post all the links and all the how you can contribute on there, and then also I update people on what's going on.
Well, and listen, if anyone down in Oregon wants to follow Tony Aiello on social media, how can they do that real quick?
On X, it's Tony Aiello Jr. no spaces, or JR no spaces, and on Facebook, it's Tony L. Aiello Jr. JR no spaces.
All right. Did you have fun tonight?
Oh yeah, this is and actually, you know what? Do you have a minute to geek out?
Yeah, dude, that's the beauty of the live thing. We don't have hard stops. We just go.
Okay, so my favorite story about this channel is one. I watched your breakdown before this even went to a vote, and that's where I started to get excited about it. But my favorite was one of our star witnesses is a local gun store owner in Burns, and.
Okay.
The way I found him is I had pulled over. I was still smoking at the time, and I pulled over, and everything's white in Burns. It's snow season. It's December, and I pulled over in just a random parking lot. Got out, took my jacket off so I didn't smell like cigarettes, and I pulled over in a gun store parking lot. I had no idea. Out he comes, and he asked me what I'm doing in this parking lot. Brings me inside, and shows me your video. A different video than I had watched. And I said, and he starts teaching me all this stuff about magazines. And I said, you want to come with me? And just in case I want to call a witness. And we get there, and Judge Ratio looks at me and goes, Mr. Aiello, call your first witness. And I go, oh no, because this was my first time calling a witness. And I go, all right, yeah, I call that guy back there.
That guy right there.
And so he had been, his name is Benny Calloway, spent cartridge in Burns, great guy, good friend, took care of me while I was out there for trial. And so this channel has been great, covering it and keeping people up to date. I see G23 in the comments, and he posted he almost became a part of the court record because the audio during closing cut out. And they were able to save it, but it was almost going to be the G23 YouTube video as part of the court record. And so there's a lot of funny things that happen just with YouTube. And ultimately, the thing we have that they don't have is we have the comments. We have guys like you who are really passionate about these issues, and the other people are passionate too, but they don't have this kind of community.
Well, I appreciate that, brother. And I tell you, I am very passionate about it. I'll tell you what else I'm passionate about is I'm passionate about good lawyering. And I told you this privately, and I said it publicly, I'll say it again. I think you've done a damn good job here, Tony. I really do. And win, lose, or draw, you did everything that you could do for the state of Oregon. And Oregon, I want you to know, and this is a young lawyer. What do you got? 5 years with a bar card?
5 years. Yeah.
5 years with a bar card. He's already been to the state Supreme Court a couple of times. That is a fantastic. You're going to have an amazing career. But Oregon, I want you to know that, hey, I know there's rough days down there, and you think, oh my God, I'm going to move to Idaho soon. But I want you to know that there are guys like Tony that are fighting like hell. So, Tony, brother, thanks for being here, man. I had a good time with you.
All right, we'll talk soon. I did too. All right,
man.
Bye now.